A conference or hearing is where the evidence about a dismissal is examined. Each side must prepare a case which includes written witness statements and an outline of submissions. And if the parties are unrepresented, they must argue the case themselves. A hearing is a formal legal process. While a conference is less formal and more interactive, both can be confusing for employees and employers. This video will help you prepare for a conference or hearing. We'll explain the paperwork you're required to submit before your conference or hearing takes place. Then we'll examine the differences between a hearing and a conference. Finally, we will look at the outcomes you can expect from this process. But first, let's quickly look inside the hearing room. You should arrive early, before your hearing is scheduled to start.
Once a person comes into the hearing room, they should make themselves known to the associate, and the associate will write down their names and who they are for the member.
The associate is the assistant to the member who conducts the hearing and decides the case. You should watch the separate video, Who's Inside a Hearing Room, for a complete explanation of who is who, where to sit, and what happens in a hearing. Before you get to the hearing room, you have to prepare the required written documents.
All the evidence that the parties want to rely on at the hearing needs to be provided in writing, so that includes an outline of submissions, any witness statements from any relevant parties, and any other documentary material.
Witness statements are considered evidence. They are first-hand descriptions of what occurred, and one is needed for each person giving evidence. This includes you, whether you are the employee or the employer. So everyone will have at least one witness statement, while some people may have many.
Anybody with anything relevant to the matter, with anything to say, can put it in a witness statement. It's just anything that was seen, heard, said, any point of view on any relevant topic.
Anyone giving a witness statement is required to attend the conference or hearing, as they need to give sworn evidence and be cross-examined. If a witness is not there, evidence may not be allowed, or it may not be given as much importance. There is an interactive form on our website to help you prepare witness statements. The other important document to prepare is an outline of submissions.
An outline of submissions is basically a document just outlining either why or why not somebody was unfairly dismissed, and just why the tribunal should find in the party's favour.
The outline of submissions is different to the evidence of a witness. It should not repeat what is said in the witness statements. It sets out the arguments about why the dismissal was or wasn't unfair. Both the employee and employer need to do an outline of submissions explaining why they think their case should succeed. You may also need to lodge other documents to support your case, like payslips, dismissal letters, emails, or other relevant materials. These should be numbered for easy reference. It's very important that all of your witness statements, submissions and documents be sent to the Commission and the other party. You will receive directions from the Commission detailing the dates by which your documents must be lodged, and it's important that you comply with those lodgement dates. Those preparations mean that at the conference or hearing, the evidence and submissions can be considered, and witnesses can be questioned and cross-examined. If you need an interpreter for the conference or hearing, please let us know in advance. We will arrange that without any cost to you. Hearings are public events that anyone can attend, but an unfair dismissal claim may be heard in a conference which is closed to the public. In a conference, the door will be closed, showing it is private. Sometimes a conference may be moved to a conference room instead of using a hearing room. Conferences tend to follow a less formal process. The member may even sit at the bar table with the parties. In a conference, evidence may be given from the bar table instead of using the witness box. To allow that to happen, the employer and employee will be sworn in at the start of the conference. The member's decision is not affected by whether you have a hearing or a conference. Neither method gives either party any advantage or disadvantage. When the hearing is over, the member will make a decision about whether the dismissal was unjust or unfair, but usually that decision won't be made on the spot. Most commonly, a decision will be reserved, which means it will be issued at a later time. You may be called back to hear the decision, or it may only be published on our website for you to read. There are only 3 possible outcomes from a hearing or conference. If the dismissal was found to be fair, the application is dismissed. If the Commission finds the dismissal was unfair, it can order the employee to be reinstated to their job or appointed to another job on terms and conditions that are no less favourable. The Commission can also order payment of compensation to the employee. Reinstatement and compensation are both called remedies. It is impossible to predict how much compensation could be awarded. Each case has unique features which play a big role in the final calculation. The Fair Work Act details how the Commission should determine compensation. It sets a maximum amount equal to 26 weeks' pay or half of the high income threshold, whichever is the lesser amount. But that maximum payment is not common, as the Act requires a number of issues to be considered. For each and every case, the Commission must take into account the length of service, the amount the employee would have earned had they not been dismissed, what steps the employee has taken to find new work, how much income the employee has earned since being dismissed, whether any misconduct was involved, and the impact of compensation on the employer's business. There is a link to information about outcomes under the Dismissals tab on our website. There are also a number of fact sheets and guides about conferences and hearings that can help you if you still have questions about these processes.